Hello there, and welcome to the podcast. I'm really excited to have Angela Buchanan Smagula with us today. She is a founding partner of Kahn and Smagula, a two-woman law firm specializing primarily in education law, and they represent a variety of schools, including public schools, which is where most of our audience kind of lives. But she also co-hosts a podcast that focuses on special education. It's called A Special Education Teacher, Administrator, and Lawyer Walk Into a Bar. All you ever wanted to know about special education. So that is another amazing resource. And I'll link to the podcast in the show notes so you can find out more. This quick bio doesn't do Angela justice at all. So, Angela, would you mind telling us just a little bit about your story? What led you to specialize in working in education law and a little bit of your journey there before we
Sure.
dive into all things due process?
Yeah, sure. No problem. Thank you so much for having me. I really appreciate it. My entrance into special education law sort of takes a circuitous route. I went to law school after working in publishing, actually. Didn't take any administrative law classes, didn't take any education law classes, didn't even know that I was aware of special education from volunteering in my high school with students with special needs. But other than that, I sort of wasn't aware of it at all. And then I was a big ticket litigator in Boston for a number of years and ended up leaving that after having my first kiddo and went to work for a municipality, the city of Newton in Massachusetts. And through working there, that city's law office was big enough that they represented everyone in the city. So they didn't have any outside representation. And that included the Newton Public Schools, which is a giant school system. It's the third largest school system in Massachusetts. And through that, I started doing education work and learning about special education and discipline and all the stuff that goes along with it. And I loved it. Really, it became sort of my life work in terms of focusing on sort of the grassroots nature of it from the school side. And the podcast that I have that you mentioned, and I appreciate that, and I hope people listen to, are two people that are much more knowledgeable than me actually about special education, an administrator and a teacher, friends of mine now through work. Through that, we've sort of carried on. And in opening my own practice, part of what we do for schools is represent them with regards to special education. And that doesn't only include due process, which we're going to talk about today. It also includes sort of like day-to-day work and guidance and being a thought partner. And, the districts that I represent, I know it can be contentious between families and school districts. And as a litigator, I don't mind that. But at the end of the day, the idea is to work collaboratively and assume good intentions. Parents want the best for their kid. School districts that are implementing special education want to, do what they think is best for their students. And so if you go in with sort of that view, I think it's helpful.
Yeah, I love that you mentioned that because that has been a common thread in our interviews is that we all want what's best for students. We don't become special education administrators to become rich and famous. There's definitely a mission behind that. And parents obviously want what's best for our kids. So it's just figuring out. Sometimes it doesn't connect quite right, but that is the ultimate goal, which makes this probably a nicer area of the law to navigate potentially. I don't know.
Yeah, well, what I often equate it to is like a marriage. So a public school system implementing special education for a student is, K through 12 or potentially K through 22. And you have to work with people despite having potentially disagreements or having to come to some sort of negotiated collaborative agreement along the way. Sometimes it's going well and sometimes it's not, but it is a relationship that lasts sometimes longer than some marriages. So, you need to be aware of that. And I think people are, and I think lawyers that become involved either on the parent side or the school side also need to be aware of that.
That's a super helpful introduction. So let's transition to chatting a little bit more about due process. So can we start with a super broad overview of kind of what due process entails within the context of special education?
So due process is a legal procedure that it's a sort of the umbrella legal procedure that allows parents and guardians to challenge decisions that are made by schools regarding their child's IEP or their child's 504. And the reason due process is available, and you'll hear about due process in all sort of walks of life, but the reason it's here is that education is a right and not a privilege. So if you have a right to something, like you have the right to free speech, you have the right to education, then along with that comes due process that allows you to engage in a way to make sure that you have that right. And so the IDEA, which is the governing, statute with regard to special education, specifically IEPs, allows for that. So speaks to that. So that when education is a right and not a privilege, then you're entitled to certain things. And so that you can exercise your entitlement to that through the due process system. Does that make sense?
Yeah, that makes sense. So the laws are intended to protect our students to make sure that they have that right.
Correct.
And so how are the laws set up to help enforce that?
So the laws are set up to help enforce that because the IDEA requires all of the states to follow their statutory framework with regard to due process hearings. And so you have an outlet when you are dissatisfied with the school with regard to accommodations and services, not following the IEP, not providing an appropriate placement, not providing FAPE, not addressing behavioral or disciplinary issues appropriately. When you have a disagreement with the school doesn't just get to say, sorry, we're right. So it allows for another level of review. And so the states all have their own regulations. In Massachusetts, it's the CMR. And so each state has regulations that further implement what the IDA proposes or mandates in terms of due process. And what that looks like, and states can always do more. So, federal law lays sort of like the baseline of what must be done. So the IDEA lays the baseline of what must be done. And then states can always do more. They cannot do less. And so as like the baseline, the IDEA mandates that states set up administrative hearings. So it's usually under like the administrative setup within that state. And hearings are held, due process hearings are held with a third party, a hearing officer, depending on what it's called state by state, that then hears evidence. So it's not just opinion. It's not just, I don't think this is right. It's not just the school doesn't get to say, this is all we can afford. The family doesn't get to say, my kid requires this because I want it, right? It's based on witness testimony and evidence. And a third party will determine, depending on what the issue is, but at the end of the day, that a student is making effective progress in the least restrictive environment and receiving a FAPE. That's like the umbrella issue that can be brought to a hearing. But within that are lots of smaller issues that can also be brought.
And what are some examples of those smaller issues?
So it can be a sort of a number of things. It can be concerning whether the school is actually implementing the IEP as written. The IEP is a contract, serves as a legal document. And of course, schools are mandated to provide a free and appropriate education in the least restrictive environment. And they need to provide enough specialized instruction for the student to be making documented effective progress. So any of those issues can be brought as narrow as you want or as broad as you want. Often placement is an issue. So the law requires that students are educated in as an inclusive environment as possible, right? Because in the old days, not that long ago, special education students were siloed in separate classrooms. And so the law changed that. But every child is unique and individual, right? And so what they need is also unique and individual. And so depending on their profile, their disability, and their need for specialized instruction, where they fall on the continuum of inclusivity can be up for debate. There can be a difference of opinion about that, and that turns on sort of where your placement is. So that's often a big issue. There's also issues as it relates to discipline. if you've listened to my podcast, that's one area that I can yammer on about forever. But special education students have the same rights as regular education students plus more. And so often there can be disagreements that can come to hearing about that as well. Essentially, anything that has to do with the creation and implementation of 504s or IEPs are going to be fair game within a certain time frame. So the statute of limitations, which is a limit on how long back you can go for claims. So like if I have a 8th grader that I'm concerned about in terms of making effective progress, documented effective progress in their program, I can't go back to 5th grade and talk about it in terms of evidence for purposes of 8th grade. I can go back that far historically, and you'll see that because it's, again, a long story. It's a child's life. But in terms of actual claims and compensation for those claims, and by compensation, I don't mean money, I mean placement or services or additional requirements that the school district has to do, it can only go back 2 years from the date that you file. So if you have a concern about an implementation of your student's IEP and you're sitting in the fall of 6th grade, you shouldn't wait till high school to bring that claim. Yeah. Does that make sense?
Yeah. So if a parent is having a concern, they need to bring it up within those 2 years.
Correct.
Yeah, that makes sense. What are the steps involved in filing a complaint, and what does that typically look like?
You do not have to have a lawyer to file a complaint. So parents can file, it's Latin called pro se, which means they file for themselves. Districts can also file pro se, but they often have lawyers available to them. You have to file an actual written document that identifies the complaint that you're making, the name of the child, the name of the school district, and the remedy that you're looking for. It doesn't have to be the best thing ever written. It doesn't have to include every single thing that you're concerned about, but it has to include an identification of issues that you want the hearing officer to decide. And even if a parent is writing something pro se, the hearing officer will get the parties together, usually telephonically, and make sure that everyone's on the same page about what the issues are. Then there can be motion practice about excluding issues that may not fall within the jurisdiction of the BSCA. That's the administrative hearing, the Bureau of Special Education Appeals. That's what it's called in Massachusetts. But any sort of administrative hearing will have areas of jurisdiction as it relates to what I said about special education being implemented pursuant to an IEP or a 504. And then the school district has the opportunity to write a hearing response. Again, it doesn't have to be your entire argument because, again, the hearing officer is not going to make any decisions based on those filings. Mm-hmm. The hearing officer is going to make a decision on at a hearing with actual live testimony and actual documentary evidence. But the filings are necessary to identify the players, the issues, the time frame, all that kind of good stuff. And then I'm sort of jumping ahead, but just to put a bookend on it, when you have an IEP due process hearing, it can go over a number of days. And then the hearing officer can sort of find the following things. The hearing officer can find that the school district's proposed IEP or the issues surrounding the IEP are appropriate and deny the family's request for changes or more services. The hearing officer can find that the school district's proposed IEP is not appropriate and actually tell the school district what changes need to be made. So amend the IEP. And then the hearing officer may find that the school district's proposed IEP is not appropriate and then order additional services, order a different placement, and legally make a decision that the school district has to follow.
So they're either deciding if it's appropriate or not, and if it's not appropriate, it may result in updating the IEP or setting up additional services or just remediation for whatever that
Correct. So compensatory services or ordering a different placement. Like oftentimes the decisions are turned on the school district saying we're able to provide FAPE in the least restrictive environment in our public school. And a parent, for example, is saying like, no, my student needs an out of district placement in a special education school. And the hearing officer has the ability to order that based on the evidence. So it's become a very legal process that often requires lawyers, which is like great for people like me, maybe not so great overall for families and special educators. Like I always say when I'm prepping my witnesses, like no one went into education to like prep with Angela and testify at trial. Like that's not why people go into special education. And families trying to get services for their students, it's not their goal to also spend time and energy testifying about why they need it. So no one's happy except for me, the lawyer, right? But because, again, education is a right and not a privilege, it inherently involves the government and the state mandating that certain processes are followed. And when that happens and it becomes codified in statute or regulation or law, it inherently requires process that often requires attorneys.
Yep. Yeah. So do you have any idea how many times someone files pro se? I guess you're allowed to do it, but do those filings tend to go well? Like, what is a lawyer eventually or attorney eventually roped in?
So there are cases that go all the way to decision that are pro se.
Okay.
For sure. What I would say is that the special education process, even attending team meetings, is an overwhelming process for families.
Yes,
And
absolutely.
and again, it's because the devil is in the details, right? So the school district has certain responsibilities that they need to follow. They need to demonstrate effective progress in the least restrictive environment. The school district's view of effective progress is not, the best possible thing ever. That's not what the law requires. And so a family member might think, I want the best possible thing required. So there's going to be inherently potential conflict in that. And then in terms of like what is being offered as specialized instruction, and with the new IEP, it can be very overwhelming. So take that and multiply it by 100 when you go to hearing, right? Because the hearing rules require a list of witnesses, like a list of documents, the ability to examine and cross-examine witnesses. So the law allows for parents to go pro se, and actually the way that administrative hearings are set up, there is some consideration made for pro se parents, right?
Okay.
But in my opinion, you're better served by having an attorney to work on your behalf. But of course, then that becomes like a financial issue. Now, under special education law, this is one of the few statutes that exist that allows for fee shifting. And what that means is if you are the prevailing party at hearing, i.e. you win the majority of the claims, then the school district has to pay for your legal fees. So they do that to open the door for more opportunities because you don't want the concept of having to pay for a lawyer restrict you exercising your rights, but you have to win. So if you don't win, then you're still on the hook for your legal fees. So it can be, sort of complicated in that way.
Yeah. I'm just curious, like if a parent brings a case, is it often super clear of like, oh yeah, we think this will be the hearing officer's decision? Like, is it easy to predict?
It's not.
Okay. Because there's so many factors, right?
Because there's so many factors, and both parties have dug in to their view that they're taking it to a third party. And usually there's going to be some opportunity. There is opportunity to resolve it short of a hearing. So if you actually are ending up at a hearing, then I think it's not straightforward. And I think it's not a slam dunk for either side. Otherwise, it would have been resolved short of that. That's not to say someone's not right and someone's not wrong. It's just that it's complicated and nuanced. Prior to filing a hearing request for due process purposes, there's lots of opportunities within the law to resolve it short of that. And that looks like a couple of things. You can do that at the team meeting level. You can do that at mediation level, Like departments of eds in all states offer mediation that's free related to the due process within that state. So you can go to mediation. Also, when you file a hearing request, the law requires the district and the parents to have a resolution meeting unless it's waived. So that's another opportunity without lawyers for people to come together and try and resolve the issue. Sometimes the threat of litigation by a family is enough for a school district to move forward. So there are lots of opportunities for these two parties to come to some sort of resolution short of a hearing.
That makes sense. My last question, just from your perspective, like what advice would you share with a school district administrator who is maybe navigating, like let's pretend it's their first due process or just like tips for due process in general? Like what would you say to district administrators in terms of maybe a couple like top considerations?
So what I would say to district administrators is to involve their council, if they can, as early as possible. In terms of like, if you think there's concerns, or sometimes if there's a disagreement about services and you're wondering sort of where to land on it, to partner with other administrators in your district that have had experience with that, or that have had experience with the family, and partner with your council, if you can, to determine sort of what the issue is and can it be resolved, or can we come to some sort of agreement prior to it getting to litigation, prior to a filing.
Yeah.
Now, other tips and advice around that is that, once there is a filing, we want to make sure from the school perspective that we have all our ducks in a row. Like,
Yes.
Is our paperwork good? Are there procedural errors that are going to be problematic for us or that are harmless? Like, we want to be able to go to hearing with the best possible position. What that means is listening to what the families have to say and understanding their position, and not just saying they're wrong because you want them to be wrong or because you think you're right. So you have to have the ability to be thoughtful and flexible to the extent that it makes sense. And then, from my perspective, and you would pick this up when you listen to my podcast and my two former colleagues, now friends, is like, be prepared. So I prepare my special education administrators and teachers so that they understand what is important in terms of evidence and what is important in terms of the issues at hand. I always emphasize telling the truth. You're testifying under oath. You must be honest. And at the same time, you must also provide the information that the hearing officer needs to hear with regard to why you're taking a position that's counter to the family. It can't just be that, like, that's what you think, right? It has to have evidence in support of that. And you have to have data. So data. Like, the data is most important for purposes of evidence, because parents will feel how they feel, and they will express concerns about progress, about programming, about instruction. And our responsibility from the school side is to be able to demonstrate and quell their concerns with data. And then if we disagree, we disagree. And so that's why it's important not to sort of get bogged down in personalities or in long-term difficulties or historical difficulties. It's really about the data and the support for why we think this service is appropriate, why we think this placement is appropriate, and why we're defending that, short of saying the kid needs something different. And at the end of the day, sometimes people are like, what's the big deal? Well, there's a financial component to it, but obviously also it's like, what is in the best interest of the child? And out-of-district placement is inherently a more restrictive setting. For some kids, that's FAPE. For some kids, it's not FAPE. And families and school districts can disagree on that.
Yeah, and that's where it gets so intricate, because what's FAPE for one student isn't for the other. But then that's why it does come down to the data of, like, are we seeing that progress and have that evidence? That's one big takeaway.
That's like my clients will tell you that I'm all about documentation and all about data. And documentation is important too, again, as it goes to sort of procedural due process. So procedural due process is about following what the regulations and the statutes say in terms of what you have to do. You know this, everyone knows this. There's X number of days that you have to do an evaluation by on when you get the consent. And there's X number of days that you're allowed to discipline someone until you have to add more process to that. And if you make procedural errors, the question becomes like, is that enough of a negative impact on the student that changes need to be made? So it's very important to make sure that you're following all the procedures, because sometimes it's harmless error, but sometimes it's not. And you want to be in the best position that you can be. And again, that process is there because that's what the student is entitled to, right? There's a reason you get handwritten notes if you're going to get the IEP 10 days later, and there's a reason why you have 30 days to respond to the IEP. Like they're not just like there to make everyone's life difficult. They're there because, go back to like my friend put it on a t-shirt for me, education is a right and not a privilege. And when you know that and you think about that, that should guide sort of all the decisions that you're making in terms of following all the, the rules and regulations.
Yeah, that's great. And do you ever work with districts on, because like it's simple when you boil it down like that, like just make sure you have your documentation and your data and keep the student's best interest in mind, and like thinking about education being a right. But I think the implementation of this gets challenging, like in a school setting, in an imperfect world where we have staffing issues and funding issues and all of that. And this would probably be a whole other podcast too. But I guess I'll keep it simple. Like, do you ever work with districts in being more proactive and setting up those types of things, or like auditing their current systems and processes or anything like that? Or
yes. So the state will do an audit on that as well. When they do the state audit, and they'll pick up on those things. But yes, I mean, I do a lot of work around that, and it's often sort of like learning by doing. So like a good example of that is when you offer something verbally in a meeting or in a conversation, and then you don't document it anywhere. And then they later say, like, I don't ever remember that. And they might not remember that, right? But you need to document it so that you have it. And it doesn't actually, what I often say, one of my catchphrases is, it doesn't really matter what the answer is. Like if you're asking for consent, you have to do it in writing. And it doesn't matter if they say yes or no, actually. It's more important that you made the offer in writing. Because later we're going to have a disagreement about it. And we're going to want to be able to demonstrate that for procedural purposes, that we asked for consent, that we made that offer, that we heard them say that they want an evaluation, and that we responded, right? I can't tell you like how many conversations and disagreements I've had where they say they offered it, but there's no evidence of it. And the family doesn't remember. And it may well not be, and they deny it. And they say that it was never offered. And it may well be that they don't actually have a real memory of that, because again, it's a stressful environment, especially if it's, sort of contentious. So it's really important to document things, and the answer almost doesn't matter.
This was super helpful. I really appreciate, I know these questions were a little tricky and super broad. There's just so many areas to dive into with this, but I feel like you did a really nice job of breaking things down and
I'm so
making
glad.
them a little bit more digestible. So thank you. So if district administrators want to kind of learn more about what you do, well, definitely share the link to the podcast. And we have the link to your practice website as well. Is there anywhere else you would want to send administrators?
Yeah, I mean, so I would shamelessly recommend listening to the podcast.
Yeah,
There's
great
a
resource.
lot of episodes. I mean, I think we're in season 4, but you can go through the episodes and click on one you want, and you can listen to them sort of like by interest. There's a lot of, because we have an administrator and a teacher, like a very experienced administrator and a very experienced teacher, now administrator, multiple decades. There's just a lot of really good specific episodes, like, the 1, 2, 3s of IEPs and about FAPE and about evaluations, like very, very specific episodes that I think would be helpful. We get a lot of feedback. Also, when we talk about these issues, like one of my co-hosts often tries to sort of like say directly, like, this is helpful to teachers because of X, or this is helpful. The takeaway we want you to have is Y. So I think it's very, very helpful and informative. If people have like individual questions that they want to raise with me, they can contact me on my LinkedIn, which I'm happy to have you include. Also, we have an email related to the podcast where people write in questions directed often at me or just in general. That's also available to people. And we get like our listeners, it's interesting, like our platform indicates like where our listeners are from. And when we first started doing this, we thought it would be sort of very Massachusetts and New England centric, but it's not. Like we have a massive amount of listeners in like Illinois and a massive amount of listeners in like a town in Kansas. Like we have a lot of listeners. And then we also have like international listeners as well, which is interesting too. So I'm happy to respond to any questions, and I can provide you the email address that you can put in your show notes if that's helpful.
Yeah, that would be great. And I also will add a link to your LinkedIn profile. But yeah, so we'll have some great resources in the show notes. They'll be linked in the description for the episode. And is there anything else? I don't want to cut you off. Is there anything else you wanted to close out with, or are you feeling?
Well, I just wanted to say in terms of like the whole continuum of due process, like I did want to mention that if you disagree, if either party disagrees with the hearing officer's written decision, and they have to write a decision that's often extremely detailed within a certain number of days, that is appealable in your state, according to the regulations in your state, often to either state court or federal court, right? And federal court has jurisdiction because of the IDEA. State court has jurisdiction because of the state regs. So that's another layer of due process that's allowed for both parties for purposes of if you think they've gotten it wrong.
Yeah. So this could end up being quite a lengthy process.
It is a lengthy process. Now, what I will say is that the law requires, and the feds have been pretty good on states, specifically Massachusetts, I'm aware of making sure that the administrative hearing officers follow their timelines. But it's still, from the day that you file a hearing request, there's going to be extensions, reasonable extensions. There's going to be a variety of things that cause things to get delayed. So let's say you file January 1, let's say you have a hearing by the end of February, then they have to generate a decision within 60 days, like you're 4 months in, right? And so there are like the ability on certain issues, and we could do this another podcast on that, for emergency expedited filings. But, it can be that you don't have a decision for months, even in the most efficient of processes. What I would say again is that like the only person that loves litigation is me. No one else loves it. So, at the end of the day, you want to try and work collaboratively. There's also, I didn't mention, opportunity to work collaboratively short of a hearing decision once you're within the hearing. So, for example, in Massachusetts, we have something called a settlement conference that a different person at the agency runs that allows for you, after filing a hearing request, to potentially resolve the case. Also, hearing officers allow for something in Massachusetts, and I know in other states, called a pre-hearing conference, where you can also try and resolve the case. The lawyers can talk to each other and try and resolve the case. So there's lots of opportunities to do that. Sometimes filing a hearing request is the only way to get someone's attention. That can be true, but that doesn't mean that you're going to definitely, go to hearing. And again, it's very time-consuming for both parties. It's very stressful for both parties. It's very expensive for both parties. And at the end of the day, you don't walk away and say, like, see you later, bye. Because even if you're placing the student out, like, you're still monitoring that placement. You're still responsible as a school district for that child's education, even if they're in an out-of-district placement that you've been told to place them in, or you have decided that you need to place them in. So it's a long-standing relationship, going back to what I said in the beginning. So hearings can take a lot out of people, all people. Everybody but me, again.
Yeah, no, that was super helpful. Thank you for breaking that down and explaining it in such a clear way. For anyone listening, thanks for joining us. Definitely check out the show notes for the resources mentioned. And thank you, Angela, for being so generous with your time and expertise. This was great.
Thank you so much. I really enjoyed it.